Good evening. Good evening. Good evening. It's great to see all of you tonight for our Yale Rosenberg Memorial Lecture. We have the honor of having Dean Erwin Chemerinsky as our speaker. And we're really proud of this lecture series named after our dear departed colleague, Yale Rosenberg. And I'll give you a little bit of data and reflections on the Yale Rosenberg Memorial Lecture. So Yale Rosenberg was an esteemed faculty member here. He was a graduate of Rice University, and he graduated from NYU Law School, where he's a Root Tilden Scholar. He joined the University of Houston Law Center faculty in '72 to pursue his true calling of teaching after his distinguished career in government. He inspired instruction in civil procedure, federal jurisdiction, professional responsibility, and Jewish law at UH Law Center, earning him the UH Teaching Award in 2000, a Teaching Excellence Award in the year 2000. He was an award-winning scholar. The Rosenberg had been called America's prophet for his analysis of the decline in federal habeas corpus. But we can't think about Yale without the love of his life, Irene Merker Rosenberg. And I unfortunately never had have the privilege of meeting either of them, but I've heard so much about them, especially through my colleagues, and have attempted to keep the flame lit on their memory at this great law school. And so he was married to Irene Merker Rosenberg, and people marveled at the great love between them for more than 30 years as marriage partners, collaborators, and colleagues. There's actually a manuscript online that people could view of their last work. And there's a memorial fund that was created after his passing that was to foster excellence at the University of Houston Law Center. And that's one of the things that we have here, that this lecture, as well as some student internships and opportunities for students, are part of that fund. Is a student writing prize, and whatnot for the students in the room is something you might want to consider pursuing. We also want to thank the Rosenberg family and their close friends, Rivka Maris Sadat, Toby Cooper, and Shirley Cooper. I know they're in the audience, right, I think, yes. Estelane Katz, Marty Katz, Leslie Wagner, Robin Wagner, and of course close friends like Professor Emerita Ellen Maris, Makila Maris, Laura Oren, who's a professor emeritus, Jerry Payne, and Linda Payne. Let's give them a round of applause for helping me and the school keep the flame alive. And over the past many years, we've had a number of really trailblazing scholars that we want to welcome Dean Chemerinsky in as part of this family of scholars who've been former Yale Rosenberg lecturers. So we had Sam Levine, who's now a director of Jewish Studies, Law Studies at Toro. When he came, I believe he was at Pepperdine Law School. He was our very first Rosenberg lecturer in 2004. And then Professor Joshua Dressler, who's a professor emeritus at Ohio State University, was 2006. Professor David Dow, our own David Dow, who specialized in death penalty work, was in 2008. Then Cornell William Brooks, who was at the time president of the NAACP, and now he's a professor of practice at Harvard Kennedy School. Our own Professor Renee Kanaki Jefferson, who's the Doherty Professor for Ethics, and actually she's now the Assistant Dean for Law Outcomes Assessments and Strategies. She's one of our own. Professor Jack Chin, Gabriel Jack Chin, who's the Edward Barrett Chair and the Director of Clinical Legal Education at UC Davis Law School. And then Professor Tanya Hernandez, who's the Archibald R. Murray Professor of Law at Fordham University School of Law. Professor Nelson Tebby, who's the Jane Foster Professor of Law at Cornell Law School. Professor Tomiko Brown-Nagin, who is the Daniel Paul Professor of Constitutional Law, Dean of Radcliffe Institute for Advanced Studies, Professor of History, Faculty of Arts and Sciences at Harvard Law School. Janae Nelson, who's currently the program and president and director counsel of the NAACP Legal Defense Fund. And last year, Noah Feldman, who's the Felix Frankfurter professor of law and director of the Julius Rabinowitz program on Jewish and Israeli law at Harvard Law School. So it's really been a great assemblage of really talented faculty members who've come and spoken to us. And we want to welcome Dean Chemerinsky into this group. And let me tell you a little about Dean Chemerinsky. And a lot of you know Dean Chemerinsky, as I mentioned during the dinner. A number of our recent or graduates have said, oh, I learned bar prep from him, is what they said. He was amazing during bar prep. So many people said that to me, that he was at bar prep and he did this without notes. He's amazing, he's brilliant. That's what I had heard. I'm sorry if I'm embarrassing you, Dean Chemerinsky. But he's an American legal scholar known for his expertise in constitutional law and federal civil procedure. Since 2017, he's been the dean of UC Berkeley Law School, and previously he served as the inaugural dean of the UC Irvine School of Law from 2008 to 2017. And you remember that's a new law school, relatively new law school in California, which was designed to be a top 30 law school. He's named a fellow of the American Academy of Arts and Sciences. National Jurist magazine named him the most influential person in legal education in the United States in 2017. And he was has served as president of the Association of American Law Schools. He graduated with a Bachelor of Science, summa cum laude, and then attended Harvard Law School, where he's a member of the Harvard Legal Aid Bureau, and graduated Juris Doctor, cum laude. He worked as an honors attorney in the Civil Division of the Department of Justice, then entered private practice. And he was named, as I mentioned, inaugural dean of UC Irvine. He became the dean of UC Berkeley School of Law, where he has the Jesse H. Chopra Distinguished Professor of Law. He's authored 16 books, including a constitutional law textbook and over 200 law review articles. He writes a regular column in the Sacramento Bee, the ABA Journal, Los Angeles Daily Journal. I don't know how he sleeps. He was also very kind today to teach Professor Morales's constitutional law class, and he sat in on one of our distinguished colloquium speakers, Professor Krause from UNC Law School. And we're really honored to have him back again. This is his probably third time, in recent times, I'll tell you about an earlier time, but his third time to the UH campus. So we want to welcome Dean Erwin Chemerinsky.
Thank you. Thank you so much for the incredibly kind introduction and the warm welcome. It is truly an honor to be here to deliver the Yale Rosenberg lecture. Yale Rosenberg is a legend in the fields of civil procedure and federal jurisdiction. I have frequently quoted and cited his work with regard to habeas corpus, and it's humbling to join the list of the people who have done this lecture before. I worry that I'm the answer to the Sesame Street game, which of these people doesn't belong? I came to the University of Houston in December of 1974 for a college debate tournament. The national debate topic that year was resolved that the powers of the presidency should be significantly curtailed. And it's easy to understand why, for the 1974-75 school year, that was the debate topic. There had been a substantial expansion of presidential power in the prior half-century. In 1973, Harvard historian Arthur Schlesinger wrote a best-selling book titled The Imperial Presidency. And Richard Nixon during those years was very much trying to expand the scope of presidential power. Today, 50 years later, we're again talking about the question of the scope of presidential powers. And that's what I want to discuss with you tonight. I'd like to divide my remarks into three parts. First, I want to talk about the framework that the Constitution sets forth with regard to separation of powers and presidential power. Second, I want to talk about how in the last half-century, there's a tremendous increase in presidential power, as simultaneously presidential power has grown and checks and balances have diminished. And then third, I want to talk about what might be done about this. To be clear, my talk is not about the current Trump presidency. It's always difficult to talk about something when you're in the midst of it, let alone at this point, only some 60 days into the midst of it. And yet I do hope that what I'm going to be saying tonight can help provide context to understand what we're seeing with regard to the Trump presidency. I would suggest to you that it is a continuation, the dramatic expansion of what we've been seeing really for the last century of American history. But the place to start is with the framework that the Constitution sets forth. If I had to start any place, I would begin with the Declaration of Independence. And if you haven't read it since middle school, it's actually worth going back and looking at it, because it itemizes 27 grievances with King George of England. And so many of them are about abuses of executive power. So it's not surprising when the first government was formed in the United States, the Articles of Confederation, it created a very weak president. I always begin my constitutional law class by asking a trick question of my students. I ask them, who was the first president of the United States? I don't call on anyone to answer that because I don't want to embarrass anyone, but the answer is actually John Hanson. He was the first president of the Articles of Confederation. He served a one-year term. As we all know, the Articles of Confederation didn't work. In large part, they didn't work because Congress lacked the power to regulate commerce among the states. Trade wars were developing. Those states that had ports were charging a great deal to landlocked states. Landlocked states were retaliating. There were tariffs, trade wars, and the country was really nearing bankruptcy. But it also failed in that the chief executive had little authority. So when there was the meeting at the Constitutional Convention in Philadelphia in 1787, which was designed to fix the Articles of Confederation, the framers decided not to do what they were charged with accomplishing, but instead to draft a new constitution. And early on, they decided that there needed to be what we all refer to as checks and balances. The notion of separation of powers wasn't unique to the United States. In England, there was thought to be a separation of powers. It was a separation of powers between the Crown, the House of Commons, and the House of Lords. But the framers of the Constitution in Philadelphia in 1787 decided that obviously wouldn't work for us. They wanted a functional definition. Using the works of Montesquieu and Locke, they decided that they would divide the legislative, the executive, and the judicial powers. James Madison in Federalist Number 10 says, "The accumulation of all powers, executive, legislative, and judicial, in the same hands is the very definition of tyranny." And so at the time, they created an elegant structure where to accomplish almost anything was take the actions of two branches of government. To adopt a law would take the Congress passing the bill, the president would be involved, either to sign or to veto it. Of course, Congress could override the veto. To enforce the law would take the executive to bring a prosecution, but then the courts to convict somebody. To go to war would take Congress declaring war, and then the president as commander-in-chief waging war. To appoint somebody, a Supreme Court justice, an ambassador, a cabinet official, would take a nomination from the president, but then it would take confirmation of the Senate. I can go on with examples of this, but the elegance of it is that checks and balances is built into that structure. And one of the things that I want to talk about, so for the last century, we've moved away from that structure. And so much can be done by one branch of government, and especially the executive branch, without needing the involvement of the other branches of government. Integral to the vision of those who drafted the Constitution was judicial review. I understand that Article 3 of the Constitution doesn't say anything about the power of the courts to review the constitutionality of legislative or executive actions, but I think I could show you that it was envisioned from the beginning that courts would have this power. It existed in most of the states at the time. Pennsylvania Supreme Court, early in American history, it exercised the power to review the constitutionality of legislative acts. Alexander Hamilton, in Federalist Number 78, outlined why judicial review is so essential to the Constitution. He said the Constitution is meant to limit the government. Those limits are meaningless unless they can be enforced. It was Marbury versus Madison in 1803 that created the power of judicial review, both of legislative and executive acts. The arguments in Chief Justice Marshall's opinion very much tracked exactly what Alexander Hamilton had said in Federalist Number 78. I always emphasize to my students that judicial review isn't incidental to checks and balances. It is quite integral to how the Constitution can be enforced. It's a number of years since I've done it, but sometimes both in law school and undergraduate constitutional law classes, for the first day I would assign my students to read a copy of the United States Constitution and a copy of the Stalin-era Soviet Constitution. I would also have them read a description of life in the Gulag by Solzhenitsyn. And the question that I would always ask them is, how can it be that the Soviet Constitution had a far more elaborate statement of rights than the United States Constitution, but had these kind of abuses? And the answer that I suggested them was the power of judicial review. How important judicial review is to checks and balances to enforcing the Constitution. I would suggest to you that what American history tells us is that when we abandon the structure that the framers intended, it often leads to disaster. Let me give you two examples to try to be nonpartisan, one from a Democratic administration and one from a Republican administration, where checks and balances weren't followed. And we recognize in hindsight that it led to tragedy. Think of the Japanese internment during World War II, during the President Franklin Roosevelt administration. 110,000 Japanese Americans, citizens, and 70% were citizens, and non-citizens, were uprooted from their lifelong homes and placed in what President Franklin Roosevelt called concentration camps. Race alone determined who was going to be free and who was going to be put behind barbed wire. Not one Japanese American was ever indicted or convicted of espionage or a crime against national security. This was entirely done by presidential executive order. The court, which was supposed to play a role with regard to checks and balances, didn't. In Korematsu versus the United States in 1944, the Supreme Court upheld this. It is now regarded as a tragically wrong decision and a tragically wrong choice by the United States. None other than Chief Justice John Roberts in Trump versus Hawaii said that Korematsu has been deemed overruled is an awful mistake. Perhaps if we'd required two branches of government to be involved, we could have avoided that. But let me give you a more recent example. And this occurred days after 9/11. And this was the torture that the United States engaged in. Two individuals in the Justice Department under George W. Bush, Jay Bybee, now a judge on the Ninth Circuit, and John Yoo, a colleague of mine at Berkeley, wrote commonly known as the torture memos. Torturing somebody is prohibited by treaty and federal statute. But Bybee and Yoo in their torture memos said that the president has the inherent authority to protect the United States, to override treaties and statutes. And they authorized extreme interrogation tactics, commonly known as torture. Jane Mayer, in a stunning book called The Dark Side, describes how that torture memo led directly to the most brutal forms of torture. There were no checks and balances. Two branches of government weren't involved. There's no indication that the torture they engaged in any way did anything to protect national security. These examples to me illustrate the dangerous path when we give one branch of government the authority to act without the possibility of checks and balances. Well, what I want to do in the second part of my remarks is talk about what's happened over the last half century, but even more over the last century. And what I want to suggest is two things have gone on simultaneously. We've seen an increase in presidential power at the same time that we've seen a decrease in checks and balances. And this is what I think has brought us to the current Trump presidency, what we've seen in just the last couple of months. It's worth starting by talking about why has there been this increase in presidential power? It's a mistake here to oversimplify. A number of different things have come together in this regard. Start with the book that I mentioned in my introduction by Arthur Schlesinger, The Imperial Presidency. He talked about how the forces of the 20th century led to a greater centralization of power. Think about three of the most important things that happened in the 20th century. One was the Great Depression, a second was World War II, and then a third was the Cold War. And each of these, he said, naturally lead to a tendency to want to centralize power. We want the government to have more authority in the time of a depression to rescue the economy. War, of course, necessitates that the president have the authority to successfully wage that war. And at the same time, the Cold War created a need for the national government to protect the United States, to safeguard the country at a time of endless war. And Schlesinger argued that these forces had led to what he called the imperial presidency. Well, these forces have continued, but let me especially talk about the last half century. One of the things that's occurred is the development of the administrative state, which increases the power of the executive branch of government. Administrative agencies, regulatory agencies, we know them, really began in the late 19th century with the creation of the Interstate Commerce Commission to regulate railroad rates. And then early in the 20th century, additional agencies got created. And then it was the New Deal that saw the creation of so many of the agencies that we're familiar with today. Things like the Securities and Exchange Commission, and the Federal Trade Commission, and the Federal Communication Commission. But agencies continue to be developed after that. One of the most important for all of our lives was the Environmental Protection Agency, created, signed into law by President Richard Nixon. The philosophy of the Constitution was that executive, legislative, judicial powers would be separate. But of course, agencies possess all of those powers. Agencies possess rule-making authority, rules that have the force of law. Agencies possess the executive power to bring enforcement actions. And many agencies have administrative law judges to engage in adjudication. These agencies, at least in some way part of the executive branch of government, and many of them are directly under the control of the president, and all of them have indirect influence of the president, and the president gets to pick the commissioners. This has contributed so much of a shift of authority from, say, Congress to the agencies, as Congress is given at the time very broad delegations of power. Think of the Federal Communication Commission. It is the authority to regulate broadcasting in the public interest. That's an enormous delegation of power. But at least since 1935, every delegation of power has been upheld. Interestingly, the Supreme Court is about to hear a case, Federal Communication Commission for Consumers Research, about whether to start imposing limits on delegation of power. And what would that mean? But at least as you trace what's gone on, the development of administrative agencies has shifted so much power to the executive branch of government. At the same time, the nature of war has changed, and that's increased presidential power. I believe that when the framers wrote the Constitution, they believed that Congress would declare war. It has that authority under Article 1, Section 8. And then the president would choose how the war was waged as commander-in-chief. But it doesn't work that way anymore. The United States has been involved in so many armed conflicts since World War II, but there hasn't been another declared war. There are constant military actions taken by the United States. They're undertaken by the president, and rarely is there any legislative oversight. If you read the news today, you saw that there was a mistake that was made by the Secretary of Defense, Pete Hegseth, that he sent out a memo with regard to the United States plans to attack the Houthis in the Middle East, and by accident shared it with a reporter for The Atlantic. But what people forget is that there's already been in the Trump administration bombing of the Houthis. Congress wasn't involved, it was just on the president. And it's not just President Trump. We can look at the actions that President Biden or that the earlier presidents took. And this has gone on ever since World War II. We can talk about the Korean War. We can talk about President Eisenhower sending troops to Lebanon in 1958, President Johnson sending troops to the Dominican Republic in 1965, and so on and so on. All of this represents a very substantial shift in power from Congress to the president as the very nature of war has changed. No doubt that 9/11 and the desire to protect the country has led to increase in executive power. 9/11 shifted so much with regard to what we wanted law enforcement to do. Usually we think of law enforcement as being there to solve crimes, to gather the evidence, to provide to the prosecutor, to gain convictions. But after 9/11, the people wanted the country to prevent future terrorist acts. And it wasn't the country we were fighting against, it was Al-Qaeda. And what we also wanted was the national government to do this, not state and local law enforcement. So as a result, there was so much of a shift of authority to the federal government in many things that were done that are quite questionable in the name of national security. I mentioned one. We're familiar with the eavesdropping that went on by the National Security Agency. Again, without congressional authority, all done by the executive. At the same time there have been these forces that have increased presidential power, we've also had a withering of Congress exercising its authority. Because if you're going to talk about separation of powers, you have to look at the three branches of government as interdependent. And if one branch plays a lesser role, another might come to play a greater role, and that undermines checks and balances. Why has there been this withering of authority by Congress? Again, I think the story is complex. Part of it is, I think, that we now are in an era when the president is one political party, and there's at least one House of Congress of the other political party, relatively little can get done. The deep polarization in our country means that unless the president and both houses of Congress are of the same political party, it's very difficult for Congress to accomplish anything. A prominent example of this occurred in 2016. Justice Antonin Scalia died on February 13th of that year. Almost immediately, President Barack Obama nominated Chief Judge Merrick Garland to fill that seat on the Supreme Court. Garland was eminently qualified. He had for a long time been on the DC Circuit, including as the Chief Judge. In fact, he had spent more time on a Court of Appeals than any Supreme Court nominee in history. And Garland was a moderate liberal to be sure, but not particularly progressive judge. In fact, many thought that Obama picked him precisely because he's the kind of person who might get confirmed by a Republican Senate. But the day that Justice Scalia passed away, Senate Majority Leader Mitch McConnell said, "We are not going to hold hearings or a vote on anyone who's nominated to fill Scalia's seat." And thus, there never was a hearing on Garland. There never was a vote on him. That seat remained open until April of 2017, when Neil Gorsuch was confirmed for the Supreme Court. I think that sets a precedent that will haunt us for a long time. I think if you have a Democratic president and a Republican Senate, or a Republican president and a Democratic Senate, none of their nominees are going to get confirmed for the United States Supreme Court, and few will get not confirmed for federal courts of appeals. But it goes beyond that. If you look at the last 2 years of the Biden presidency, when you had a Republican House of Representatives, Or if you look at the last 2 years of the prior Trump administration, or the last 2 years of the Obama presidency, where you had a president of one party and at least one House of Congress controlled by the other, almost no legislation got passed. But even when you have a president and a Congress of the same political party, it's very difficult to get legislation adopted. Some of this is because of the filibuster in the Senate. Other than budget reconciliation matters and nominations for the federal courts or cabinet, anything else can be subjected to a Senate filibuster. It then takes 60 votes to be able to end the filibuster for the matter to be able to pass by the Senate, no matter what the House has done. For many of us, our image of the filibuster comes from the movie Mr. Smith Goes to Washington, where a courageous Jimmy Stewart held the podium in the Senate until he literally collapsed of exhaustion while fighting corruption. It's often forgotten that in the 1970s, and then again, the Senate changed the rules of the filibuster. A filibuster doesn't require that anybody hold the podium. It's really a virtual filibuster. All the minority party needs to do is indicate their desire to filibuster. The Senate then goes on with all of its other business, and until there's 60 votes to have cloture and end the debate, nothing comes up for a vote. The filibuster makes it very difficult to get legislation through the Senate. It's made even harder by the way in which the Senate is constituted. We're all familiar that there's 2 senators per state. That was one of the great compromises at the Constitutional Convention. It was the compromise between the larger states that wanted Congress to have its representation allocated by population, and the smaller states that wanted the allocation to be equal among the states. And the compromise was have a Senate with 2 senators per state and a House with representation allocated based on population. At the time the Constitution was written, the difference between the largest state and the smallest state in population was 12-1. Today, the difference between the largest state, California, and the smallest state, Wyoming, is 68-1. I can put this to you another way. In the first 2 years of the Biden presidency, there were 50 Democratic senators and 50 Republican senators. The 50 Democratic senators represented 42 million more people than the 50 Republican senators. The result is that senators representing just a little bit more than 20% of the population can block any Senate action by the filibuster. The result is a Congress where it is so difficult to have government action. It's not surprising that in the last opinion poll I saw, the Senate and Congress have an approval rating of 16. And I wonder if that's 16 people and not 16%. But as the powers of Congress have withered, as Congress has done less, presidents have done more. And you find in administration after administration, presidents are trying to do more and more by executive order that might previously have done by legislation. In addition to all of these, I want to talk about another thing that's contributing to the increase in executive power, and something that's really important right now, and that's the development of what's called the unitary executive theory. The unitary executive theory is the idea that there's one president who's in charge of the entire executive branch of government. And the president has the authority over that entire branch of government. The unitary executive theory originates from young lawyers in the Reagan administration in the early 1980s. Among them were John Roberts and Samuel Alito. When Samuel Alito was nominated for the Supreme Court, and at his confirmation hearings in January 2006, one of the primary arguments against his confirmation was his advocacy for the unitary executive theory in the Reagan administration. The unitary executive theory says that Congress can't check certain things with regard to the executive branch of government, that Congress can't limit the removal of cabinet officials, or maybe anyone in the executive branch, that the president has a great deal of authority to command anything that the executive branch does. I want to talk more about the case of Trump versus the United States from July 1st of 2024. But at one point in the majority opinion, Chief Justice Roberts says that under the Constitution, the president is the only person who's an entire branch of government. That is very much expressing the philosophy of the unitary executive theory. And so it's all of this that leads to what President Trump is claiming now in terms of the powers of the president. Let me give examples so you can put it in the context of what I discussed. President Trump is claiming that he has the authority to fire any heads of agencies, notwithstanding federal statutes that limit firing. So we've seen, for example, him fire a commissioner on the National Labor Relations Board, Gwen Wilcox, even though the federal law says that she's entitled to serve 5 years until 2028 unless cause is shown for removal. He's fired commissioners from the Federal Trade Commission. He's fired a commissioner on the Federal Election Commission. All of these individuals have statutory protection from removal. In 1935, in Humphrey's Executor versus the United States, the Supreme Court said that Congress can create agencies and Congress can limit the removal of the heads of those agencies to where there is good cause for firing. That involved the Federal Trade Commission, the same agency for which President Trump has just removed commissioners. The Supreme Court in the last 90 years has never overruled Humphrey's Executor. Now, what the Trump administration has said explicitly is that Humphrey's Executor was wrongly decided. The Trump administration will not comply with it and has fired people, notwithstanding statutes that limit removal to cause. The argument that they're making is the unitary executive theory. The Trump administration is going beyond, though, commissioners of agencies. They are saying the president can fire anyone who works in the executive branch of government because it is a unitary executive. So the argument that's being made is that the civil service statute is unconstitutional. The civil service statute was adopted in the 19th century. It's about making sure that those who work with the federal government are chosen and rewarded not on the basis of patronage, but on the basis of merit. And what we've never seen before is a president arguing that because of the unitary executive theory, even civil service is unconstitutional. The president can fire anyone. A second thing we're seeing from the Trump administration is a claim of an ability to impound federal funds. President Trump is not the first to claim that this is a power of the president. You might find examples going back to Thomas Jefferson of presidents not spending all of the money appropriated. It was Richard Nixon, though, in the early 1970s, who claimed the authority to impound funds. As you know, the way in which appropriations work is Congress passes a spending bill, the president can sign it or veto it, Congress can override the veto, and however it comes into law, it is then a requirement that the money be spent. President Nixon said that as president, he had the authority to impound funds, to refuse to spend money appropriated by statute. President Nixon did this an unprecedented number of times, and virtually every time a court ruled, they said it was unconstitutional. They said that President Nixon was usurping the spending power, quintessential authority of Congress, the power of the purse. In Train versus City of New York in 1973, the Supreme Court declared invalid President Nixon's impounding of funds under the Federal Water Pollution Control Act. The Supreme Court said Congress appropriated this money for federal water pollution control. The president had no authority to refuse to spend it. In 1974, Congress passed the Impoundment Control Act that prohibits presidential impoundment of funds. A beleaguered Richard Nixon reluctantly signed it into law. Since 1974, no president, Republican or Democrat, has asserted the authority to impound funds. In December, Elon Musk and Vivek Ramaswamy wrote an op-ed in the Wall Street Journal in which they said they believed that the Impoundment Control Act was unconstitutional and that a favorable Supreme Court would rule in that direction. Russell Vogt, who's now the head of the Office of Management and Budget, in his confirmation hearings this year, said explicitly that he believed that the Impoundment Control Act was unconstitutional and that the president could refuse to spend any money appropriated by statute. And so on Monday night, January 27th, we saw President Trump freeze as much as $3 trillion in federal spending, claiming the authority to impound funds. And we've seen the president claim that authority through a great deal of other spending, all of which is now being challenged in the courts. Closely related, President Trump has claimed, as part of his authority, abolish federal agencies. On last Friday, President Trump signed an executive order to abolish the United States Department of Education. Earlier, he created, through executive order, an elimination of the United States Agency for International Development, shifting the authority to the Department of State. Agencies are created by federal statute. The United States Agency for International Development was created by Congress during the Clinton administration. The Department of Education was created by Congress by statute, taking what had previously been the Department of Health, Education, and Welfare and separating to a separate Department of Education. One would think that if Congress creates the agency, only Congress can eliminate the agency. But the president is claiming that that's his authority because it's part of the executive branch of government and it's a unitary executive. He commands all of it. And of course, we're seeing President Trump say that by executive order, he can command what the executive branch does. And we've seen more executive orders in the last 60 days than most presidents will issue in 4 or even 8 years in office. Some seem in direct conflict with the Constitution. On January 20th, President Trump issued an executive order to end, quote, birthright citizenship in the United States. After February 19th of this year, a person would be a citizen only if their parents were citizens or only if their parents had green cards. So far, 4 federal districts and 2 circuits have declared that unconstitutional, but I use as an example of the use of executive orders. But I think all of this comes in some ways the culmination and also an expansion of what we've seen in terms of the growth of presidential powers. Well, I said to you that what we've seen is 2 things simultaneously: the growth of powers and also the diminishing of checks and balances. And I want to talk about how that has happened as well. Some of it, of course, is as Congress becomes less active, as Congress withers in its authority, you see a loss of checks and balances in that way. But we've also seen a loss of checks and balances in other ways over the last half century. One is, I would say, an abdication of the court for any involvement in anything touching on foreign policy. That in essence, what the Supreme Court has done is acquiesce to the president's claim of authority. We saw this during the Vietnam War. Over 24 lawsuits were brought arguing that the Vietnam War was unconstitutional because the president was waging war without a congressional declaration of war. In each of these cases, the lower courts dismissed, the Supreme Court never granted cert by saying it's a political question. It's left to the elected branches of government to work out. It was a constitutional question. Did the president, as commander-in-chief, have the authority under Article 2 of the Constitution to wage that war? But the Supreme Court didn't get involved, and the lower court said, we leave it to the other branches of government. In 1973, Congress passed the War Powers Resolution, try to prevent, or at least make it less likely, the United States would get involved in a protracted war without congressional approval. There have been many lawsuits over the last half century arguing that presidential actions violated the War Powers Resolution. But time and again, the federal courts have said, we're not going to get involved. And that then means by not getting involved, the president is able to do what the president wants. This abdication with regard to foreign policy is seen in other matters as well. I mentioned the case to you of Trump versus Hawaii from 2018. This involves what was commonly referred to as the Muslim ban. When Donald Trump ran for president in 2016, he said he wanted, by executive order, to keep Muslims from entering the United States. A week after his inauguration in 2017, he adopted an executive order to limit individuals from 7 designated countries from coming to the United States. All of those countries had populations that were 95% Muslim. That executive order got struck down and never rolled on by the Supreme Court. He issued a second executive order, and it expired before the Supreme Court could rule. And then he issued a third by proclamation that prohibited immigration in the United States from 8 countries. 5 were on the original list of Muslim countries. The other 3 that were added were Venezuela, North Korea, and Chad. I looked at the time. Do you know how many people come to the United States each year from North Korea? 18. And no one knows why Chad got itself on that list. But by the time the case got to the Supreme Court, it was removed. Perhaps so the Solicitor General wouldn't have to answer the question, why is Chad on this list? Every lower court, district court, and court of appeals to rule on any one of these 3 executive orders declared them unconstitutional as impermissible religious discrimination. There were dozens and dozens of statements by Donald Trump and others that this was meant to be a Muslim ban. Justice Sotomayor's dissent has 2.5 pages of quotations saying this was a Muslim ban. But the United States Supreme Court, in a 5-4 decision, ruled in favor of President Trump. The Supreme Court said, this involves immigration, which is related to foreign policy. We give great deference to the president as a foreign policy, therefore, only rational basis review. And under rational basis review, you might remember, any conceivable purpose is sufficient. You don't look to the government's actual purpose, and that therefore, the Supreme Court upholds this as constitutional. These are all examples of the abdication of the courts in the areas of foreign policy, and the abdication which then means loss of a check on the president. At the same time, the Supreme Court has expanded the immunity of the president from civil or criminal suit. In 1982, in Nixon versus Fitzgerald, the Supreme Court ruled that a president cannot be civilly sued for money damages, has absolute immunity when it comes to any official acts taken in office. Case involved Ernie Fitzgerald, an analyst in the Defense Department. He testified before Congress about cost overruns in building a transport plane. Nixon was furious at him and said, fire that man. In fact, Fitzgerald had great evidence. It was on the White House tapes. Fitzgerald sued Nixon for violating Fitzgerald's First Amendment rights to freedom of speech and to petition Congress for redress of grievances. But the Supreme Court, in a 5-4 decision, said a president cannot be civilly sued for any official acts taken in office. And as I mentioned, on July 1st of last year, in Trump versus United States, the Supreme Court for the first time said that a president cannot be criminally prosecuted for anything done that's an official act taken with regard to constitutional duties. Chief Justice John Roberts wrote the opinion for the court. Justices Sotomayor and Jackson wrote dissents, which Justice Kagan joined. And it's stunning to compare the approach of the majority in its premises with the approach of the dissent in its premises. The majority begins by saying that the framers of the Constitution intended there to be a vigorous executive, and that therefore to allow the possibility of criminal prosecution would chill the president from being aggressive in the way the Constitution intended. The 2 dissenting opinions say that the framers of the Constitution deeply distrusted executive power, that the core of the rule of law is that no one, not even the president, is above the law, and to give the president absolute immunity is inconsistent with what the Constitution intended. But there's no doubt that the expansion of immunity lets any president know that whatever he or she does can't face civil or criminal liability so long it's an official act taken pursuant to a constitutional or statutory provision. At the same time, less famously, the Supreme Court has made it extremely difficult to sue federal officials when they violate the Constitution. My students are always surprised to learn that you can't bring a lawsuit against somebody under the First Amendment for money damages, or you can't sue a police officer for excessive force under the Fourth Amendment. That instead, if it's a state or local officer, you have to bring the suit under 42 United States Code, Section 1983. And there is no comparable statute that allows suits against federal officers. In 1971, in Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, the Supreme Court said you can bring a suit against federal officers when they violate the Constitution directly under the constitutional right. That involved a situation where officers of the Federal Bureau of Narcotics broke into Webster Bivens' home in the middle of the night, conducted an incredibly abusive search. Justice John Marshall Harlan, no liberal, in a concurring opinion said, for people in Bivens' shoes, it's damages or nothing. And for the next decade, the Supreme Court continued to expand the availability of Bivens suits. But since 1980, 45 years now, every single Supreme Court case about Bivens has narrowed its availability. So now it is virtually impossible to sue federal officers for money damages when they violate the Constitution. Federal officers are part of the executive branch of government. So beyond the immunity of the president, it's very difficult to sue federal officers. And even if you can sue them, they'll still have a defense, sometimes absolute immunity or otherwise qualified immunity. So I've talked about how the Supreme Court has contributed to the loss of checks on the president, but I also want to add one other loss of a check on the president. At least right now, impeachment and removal is not a realistic check on the president. I remember very much the House Judiciary Committee holding hearings in 1974. I remember Texas Congresswoman Barbara Jordan from those hearings. And I believe that the reason that Richard Nixon resigned in August 1974 was he knew that if he didn't, the House was going to vote the articles of impeachment that the Judiciary approved, and the Senate would remove him. What we learned during the Trump presidency is, given our intense partisanship, impeachment and removal is not a check, especially at a time when the president is the same political party as both houses of Congress. Ask yourself, what would it take in terms of unconstitutional conduct? What would it take in terms of egregious behavior that would be enough for this House of Representatives to impeach, let alone for 2/3 of the Senate to remove? And keep in mind then that the president now, future presidents know, that with regard to their conduct, much of it isn't going to be subject to judicial review at all, that they can't face civil or criminal liability for what they do, that the officials who carry out their policies aren't likely to face any liability, and they don't have any threat of impeachment. This is what I mean by the waning of checks and balances. At the same time, there's been an increase in presidential power. Well, this then brings me to the third and final part of my remarks. What should we do going forward? Obviously, I think that we should embrace what the framers intended. We should try to go back to a system where it really does take 2 branches of government to accomplish almost anything. We certainly should look to find ways to revitalize Congress and have Congress play the role that was intended by the Constitution. But I don't have any easy ways for that to occur. I can certainly come up with some suggestions. Congress could pass a law that creates the ability to sue federal officers for constitutional violations, an analog to Section 1983. Congress could play a much more aggressive oversight function. Congress could take much more seriously than the Senate recently did, careful scrutiny of presidential nominations. But ultimately, I believe that if there's going to be checks and balances, it's the judiciary that's going to be most important in the years ahead. And in that sense, I do have some suggestions with regard to the judiciary. One is, I think the judiciary should adopt the approach to presidential power that it violates separation of powers for one branch of government to interfere or usurp the powers of another branch of government. This isn't a radical notion that it should violate separation of powers if one branch of government interferes, usurps powers of another branch of government. You find it expressed in an opinion by Justice William Douglas, concurring in Youngstown Sheehan 2 versus Sawyer. You might remember that case. It involved President Truman seizing the steel mills. And he said, I was doing this in order to make sure there was steel for the Korean War, steel being essential for the war effort. And the Supreme Court, in a 6-3 decision, declared that unconstitutional. And people, in talking about Youngstown, always focus on Justice Jackson's concurring opinion. They tend to forget Justice Douglas's. What Justice Douglas said was, the problem here is that when property is taken for public use, the government has to pay just compensation. So when President Truman is seizing the steel mills, that's a taking that requires that Congress pay money. Congress has the spending power. For the president to force Congress to spend money is for Congress to usurp the power of the purse. United States versus Nixon, I think, was the most important case about separation of powers in my lifetime. It involved whether or not the Watergate special prosecutor could require that Richard Nixon produce tapes of White House conversations. Nixon claimed that he had executive privilege, the ability to keep secret conversations with a memorandum of advisors. The Supreme Court unanimously ruled against President Nixon. It was 8-0. Chief Justice Burger wrote the opinion for the court. What's notable is that the Supreme Court recognized that presidents have executive privilege, even though it's not mentioned in the Constitution. But the Supreme Court said executive privilege must yield if it usurps and infringes the powers of another branch of government. The Supreme Court said for the president to invoke executive privilege and keep the courts from having the evidence that they needed for criminal trials undermined the role of the judiciary in providing a fair trial. In other words, the court was saying that the president violates separation of powers if the president usurps or interferes with the powers of another branch of government. The Supreme Court needs to adopt that approach in a consistent way. From that perspective, then, presidential impoundment of funds should be unconstitutional, even apart from the Impoundment Control Act, because the president is usurping the power of the purse that's given by Article 1 to Congress. When I talk about what should the court be doing, I think it's also essential that the Supreme Court reject the idea of the unitary executive theory. Again, I want to try to convince you that this isn't a radical claim. In 1988, the Supreme Court, in a 7-1 decision, clearly rejected the idea of the unitary executive theory. None other than Chief Justice William Rehnquist, no liberal, wrote the opinion for the court. It involved a federal statute, the Ethics in Government Act. And the Ethics in Government Act said, when there's allegations of improprieties by the president or high-level executive official, a 3-judge federal court would appoint an independent counsel, and the independent counsel could be removed only for cause. An argument was made that this was unconstitutional, that it's a unitary executive and the president has to be in charge of all prosecutions, and limiting presidential removal is unconstitutional. Chief Justice Rehnquist, writing for the court, rejected that. He said it's permissible under the Constitution for Congress to vest the appointment of inferior officers in the president, the heads of departments, the lower federal courts. And even more important, the court said, it is permissible for Congress to limit removal where it's an office where independence from the president is desirable. Only Justice Antonin Scalia dissented and adopted the idea of the unitary executive theory. Chief Justice Rehnquist, in his majority opinion, responded to that. He said, our Constitution doesn't create independent branches of government. It creates interdependent branches of government where checks and balances are essential. The problem with the unitary executive theory is it doesn't recognize interdependence in checks and balances. Finally, with regard to what the courts need to do, it's to enjoin unconstitutional presidential actions and to insist that their court orders are complied with. Done a lot of research over this in the last couple of months, and what's striking to me is that throughout American history, both Republican and Democratic presidents have complied with court orders, even when they strongly disagree with them. President Franklin Roosevelt strongly disagreed with the court decisions striking down New Deal programs. He responded in part in anger by proposing court packing, but never did he suggest disobeying court orders. I just mentioned United States versus Nixon. Complying with the court order there predictably ended the Nixon presidency, but President Nixon complied with that court order. Many people have quoted the words of Andrew Jackson to John Marshall. He made his ruling, now let him enforce it. Andrew Jackson never said that. It's apocryphal. It was first attributed to Andrew Jackson 20 years after he died. And it involved a Supreme Court case, Worcester versus Georgia, that involved a court order to the state of Georgia, not a court order to the President of the United States. Of all of the things that have occurred in the last couple of months, what scares me most are the suggestions that the President might defy court orders. The President himself said, and I quote, "He who saves the country violates no law." The Vice President said that the President doesn't have to comply with court orders when it involves legitimate executive power. But if the President can violate court orders, then there is no limit on what the President could do. Then no longer is there a government under the rule of law. It was Benjamin Franklin at the Constitutional Convention who said, "A republic, if you can keep it." And what we might see, maybe in the months and next few years ahead, more than ever, is whether we can keep it. Thank you.
Thank you, Erwin Chemerinsky. That was great. So great. Any questions? I see one back there. It's you. Reading your Oprah.
I hope your pedometer. You get your steps.
Very impressive, Dean Chemerinsky. My question is, we could cross our fingers and, say our kinahura and hope that the President will comply with the orders from the courts. But if you could take it to the next step, if the Supreme Court, and some people define a constitutional crisis if the President defies any court order, some say if it's only defies a Supreme Court's order, but let's hypothetically say that President Trump defies a Supreme Court's order. Then what? Does the Supreme Court order the federal marshals out to call out the national? What is the next step to enforce that order?
Let me unpack your question step by step. Everybody in the United States, including the President, has to comply with every court order. And what the Supreme Court has said is, if you don't like a court order, the appropriate step is to appeal, not violate it. And if you want a case where the Supreme Court said that explicitly, it was Walker versus City of Birmingham. It involved Dr. Martin Luther King Jr. leading a march in Birmingham in violation of an unconstitutional court order. And the question is, since the court order so clearly violated the First Amendment, could he still be punished for it? And the Supreme Court, in language that may be very important, said explicitly, court orders must be complied with until they're vacated or overturned. And if you don't like a court order, appeal it. If you violate it, you can be punished. And that's what led to Dr. King writing his famous letter from a Birmingham jail. So it doesn't matter whether it's a court order from a federal district court or from the Supreme Court. But what happens if the court order is violated? Well, there's the possibility of criminal contempt. The problem with that, though, is it takes the Justice Department to prosecute criminal contempt, and the President can pardon as to criminal contempt. The President can't pardon as to civil contempt, And civil contempt can include being put in jail until the person complies with the court order. But that's carried out by the United States Marshals, who are formally a part of the Justice Department. So what happens if the president says, I'm going to defy court orders and circumvents any contempt power in the ways that I described? Then we have a constitutional crisis like we've never seen before in American history. And then the question is, would that be enough for Congress to impeach and remove? Then the question would be, what do the American people do under those circumstances? Because if the president can violate the Constitution and ignore court orders, then the president can lock up me or anybody else and ship us to El Salvador, and there's nothing that we can do about it, because a court order would be ignored. I hope we don't come to that point, and I hope that whatever the blustering by the Trump administration, that ultimately they'll comply with court orders.
From former U.S. attorney, there's a question.
So my only question is, and let me preface this by saying I'm a big fan of Lincoln, so let's just say that. But the prize cases, when I think of presidential power, and I think of really presidential power for the first time really showing through, it's the prize cases. How do we square that with what this, it seems like that would be a big argument that this administration will make is, we have the prize cases and that sets our power limits.
The prize cases involved the authority of President Lincoln to block southern ports early in the Civil War. And it was a claim of a president's authority to use military force that wasn't authorized by statute. And so I think what you can say is that the prize cases was an early example of a president claiming unchecked authority, acting without two branches of government. It wasn't the first time this had been done. When President Polk was in office, he ordered Zachary Taylor, a general, to march along the border with Mexico to try to precipitate the Mexican-American War that ultimately led to Texas being a state. Lincoln just took it much further. There's been some claims that Lincoln violated a court order. I think much more recent scholarship, and I can give citation to it, say that Lincoln didn't violate any court order, but it was the use of unilateral executive power. And was it justified? Did the ends justify the means? It's interesting, President Buchanan took the position that the secession of southern states would be legal under the Constitution, that there's nothing that prohibited such secession. President Lincoln took the position that the secession was illegal, that we're an indivisible union. And Noah Feldman, who was here last year, wrote a wonderful book on just that subject. But the specific answer to your question is Lincoln's use of the military in the prize cases and the ultimately upholding them would fit the example of the president of the authority to use troops without congressional approval.
It was 1, 2, 3, 4.
Dean Chemerinsky, thank you for your thoughts. My question is, how do you view the efforts of the executive branch to impeach or prosecute members of the judiciary for acts undertaken in their official capacity?
Chief Justice John Roberts is no liberal. As I mentioned, he wrote the opinion in Trump versus United States. But I applaud John Roberts for the statement he issued last Tuesday morning that never in American history has a judge been impeached because of disagreement with those judges' rulings. An anecdote here. In 1998, I got to go to Russia to speak at a judicial conference. And there were judges from a number of countries. And a Russian judge came up to me, and he had his translator with him. His question was, how do you remove judges in the United States? And I gave a far too complicated answer about, well, there's state judges and there's federal judges. And he interrupted me with the translator and said, how do you remove judges in the United States? And ultimately I said, it would take a majority of our House of Representatives and 2/3 of the Senate, and it's only been used in American history when there's corruption. And then he said that in his country, judges get removed from the bench if those in power disagree with them. And of course, if you go back to the Declaration of Independence, it was one of the 27 grievances that was listed there. The idea that a judge can be removed because the president disagrees with the rulings is so inconsistent with all of American history. And to put it in the context of my talk, it'd be inconsistent with the idea of checks and balances, because then we would have the court no longer functioning as a check if the president could just fill the bench with those who agree with the president.
One else.
Thank you. Thank you. Hello. Okay. Thank you for this lecture and also this wonderful lecture this morning about the First Amendment. I really appreciated it. My question is, we've been learning in con law a lot about how the federal government has been gaining more and more power over the 2 centuries or so, while the state governments have been essentially losing the power, especially in something like Commerce Clause. My question is, when it kind of comes to, I guess, fixing the separation of powers, how do state governments and how do their power fit into this whole jigsaw puzzle?
I think the increasing complexity of society, the increasing complexity and size of the economy, technological developments make it inevitable that so much more needs to be done nationally than locally. Also, there's always the question, I'm sure you talk about your common law class, between when do we want uniformity as a country and when do we want diversity? And I think we rightly made the choices that, especially with regard to certain values, we want uniformity, we don't want diversity. We don't want to leave to states to be able to make their own choices, where the race discrimination or sex discrimination or sexual orientation discrimination, that we want national. And that's reflected in the Civil Rights Act of 1964. It's reflected in the court's decisions, starting with Brown versus Board of Education. But you're right that there has been this increased nationalization of power. And I think one of the things that we'll see over the next months and years is liberals trying to use what's been a conservative doctrine of federalism to try to check federal power. Throughout American history, states' rights has been thought of as a very conservative doctrine. It was used in the early 19th century by those who were trying to preserve the institution of slavery. It was used to oppose Reconstruction. It was used from the 1890s to 1936 to strike down progressive federal legislation. It was used in the 1950s and the 1960s by segregationists to try to oppose the end of Jim Crow laws. Now I think you're going to see state local governments trying to use federalism. As an example, there's a principle, maybe you studied it in con law, the anti-commandeering doctrine, that the federal government can't commandeer state and local governments. Comes from cases maybe you read, like New York versus United States, Prince versus United States, NCAA versus Murphy. Well, what you're finding is the state government's now saying that the federal government can't force them to cooperate with immigration and customs enforcement, because that would be impermissible commandeering. And it'll be interesting to see how that plays out with states trying to use federalism to insulate some of their choices from the federal government. And I'm talking here, of course, about states like California or New York, Washington, Oregon, Illinois that are doing this.
Hi, Dean. It's an honor to be here. I want to say thank you for helping me get through con law. But my question is kind of for my generation. I'm a 3L. I'm about to enter the workforce in October. And the general consensus from a lot of my classmates is kind of despair, right? Like, what are we supposed to do? What is going to be done about the attack on rule of law? And listening to your lecture and just reading the introduction in your book, I kind of think the solution from listening to your lecture today is Congress. So is it our best course of action to call our senators and call our congressmen and kind of charge them with that action? Or what else can be done? Like, what can we do? And what is an immediate step of action to combat what's going on?
I don't know if you've had your admitted students day or weekend here yet. I got to speak at ours a week ago Friday, and I said to the admitted students that I think there has never been a more important time than now to go to law school or to be a lawyer. That if our democracy is going to survive, if the rule of law will be upheld, it will be because of the efforts of lawyers and judges. And so that's the beginning part of my answer to your question. Yes, I think that having Congress fulfill its constitutional functions is crucial. And in preparing this talk, where I struggle is, I'm not sure how. I mean, yes, call senators and representatives, but how do we overcome the partisan gridlock? How do we overcome a situation where it appears that the current Congress will actually rubber stamp what the president wanted? And I don't know that it'd be any different if Kamala Harris had wanted to be a Democratic Congress. It's just the moment that we live in. And if there is one house of Congress of a different political party than the president, as I said, then everything gets adopted. So I think the solution, in large part, needs to come from Congress, but I'm at a loss of what to suggest. I mean, I understand why there's enormous frustration with Democrats in Congress now, but I also recognize that the minority party in Congress is so limited in terms of what it can do.
Book signing afterwards, so last question.
Thank you so much for the talk. So this is really a compelling story of 120 years of a one-way ratchet, basically, towards more executive authority and less power in the other branches. And the suggestions at the end seem quite sensible, you know, do the opposite of that. But I'm curious what you think the underlying mechanism of the one-way ratchet is, because that, to me, is directly underlies the question of like whether you can go back. So no one's forcing the courts to abdicate responsibility for imposing liability on the executive. No one's forcing Congress to fail to pass laws, to create all these administrative agencies that make rules instead of Congress making laws directly. This is a bipartisan consensus, as you explained in the talk. So what is making everyone hand all their power to the president? And if, for example, the answer is you really can't govern a 300 million person country in a world where you have to get two branches of government to agree to everything, what is the hope that we're going to go back to that system?
I think it's a great question. And I want to suggest that the answer to the question comes from within it. There's nothing that is inherent that requires that it be a one-way ratchet. And I don't believe that it being a country of 330 million people requires it. So let me go through some of the examples that I talked about. I don't believe that there's anything that is inherent that requires that the judiciary let the president do whatever the president wants in foreign policy. That there's no reason that the courts can't enforce those provisions of the Constitution, just like all other provisions of the Constitution. And I mean, even further, when Congress tried to put some limit on an executive action in foreign policy, the Supreme Court in Zivotofsky versus Kerry said, no, Congress can't limit the president for policy. That's not right. The Supreme Court could change that. Or take the examples of immunity. I don't foresee that this court is likely to revisit Nixon versus Fitzgerald or Trump versus the United States, but they weren't inevitable. It wasn't like anything, to use your words, of a country of 330 million people led us to do that. It was very much a policy choice in that regard. And it's not inevitable that the Supreme Court was going to eliminate Bivens for all practical purposes. Congress could change that. And I give these few examples. I think I can give a lot more, that I think if the court and Congress were to assert their authority, we could go much more back towards the checks and balances that were envisioned. And Dean Baines was so kind to mention my signing the book, No Democracy Lasts Forever. I think I should mention, when you were kind enough to invite me here the last time, I presented the idea for that book before I had put the first words on paper. The first place where I tried them out was here. And I want very much to take what I said to you tonight, it's the first time I've ever done this lecture, but to write it up as another book on presidential power. So thank you so much for inviting me and having me.